So you own multiple businesses. You're not just an attorney. You're actually the owner of your company. You own one of the best clubs in Tampa.
Club Prana, if anyone's coming to Tampa through, I'll get to let you guys in free.
First party property loss is not that sexy. What made you choose this?
I chose this, so when I first became an attorney, I knew that I wanted to find a way to help people and not have to charge it to them. That was a really issue for me. I was working for attorneys that were charging $350 and $400 an hour, and when someone reaches out to an attorney, it's in the worst moments of their life. And no matter how much money you may have, $400 an hour adds up really fast and is very unreasonable to me. So I was like, I gotta find some way to help people and not have to charge them. And so I had a client who came in who the insurance company had screwed them over, and it changed my life. And so that was about 6 years ago. And so I didn't know anyone in this area of law. You don't learn it in law school. Most attorneys I know have no idea what first party claims are. They're like, what are you talking about? So I had to figure it all out. Every demand letter I have, everything I created, all was created by myself. And it was because I wanted to figure out a way. And so like in Florida is where we started. The best part about Florida is they have statutory attorney's fees. And that was what changed everything. I was like, oh my God, I can charge the person who's doing wrong to them for this litigation. Amazing. And so that's why I did it. And then I got really attracted to hurricane claims after hurricane. So if you know us, we do a lot of pro bono work. We give food, gas, water. We take RVs out there. We're boots on the ground. We get there right away because I volunteered first with Hurricane Katrina and realized there was nobody there. No one's there helping them. And then when I learned about insurance claim and realized they had no idea what they were doing.
So we are going to talk a little bit about appraisal.
Insulting.
I love questions,
so you can throw up your hands and we can make this an open conversation. If you think of anything, just kind of spit it out. I think one of the cool things about these kind of events is that, especially with where we're at here, with the path to indemnity, the idea, especially for the new ones that are here, is for us to kind of bridge that gap and create a world where there isn't such a stark difference between insurance companies and the other side. And so we are all about honesty, integrity of the claim and the file and the entire process throughout. So with the appraisal process, what's so important, I know there's already been a couple people who have talked about it, so I'll try to kind of click through some of the stuff we have so then I can leave it to where you guys can ask whatever your questions. It can be more of a forum. But the insurance companies are absolutely using the appraisal process more. And what that means in our industry, as more PAs come in, more attorneys come in, more claims start happening, is there is underqualification. I'm sure you guys have been seeing that. Undereducation, and the appraisal process is getting very, very messy. And there are not, most of the states don't have any real clear rules on what you have to do. Besides, sometimes they'll say what you have to be qualified. And then the only real rules are a little bit within the policy. So what we'll go through and kind of show you in the PowerPoints is saying that you want to take control of the claim in the process. You want to be the person to say, okay, that's what I try to educate everyone on is like, the insurance company shouldn't be the one pushing the claim. They should not be the one deciding what happens and when it happens. And that's what they do. And it's real easy to fall victim to that, especially in this appraisal process. So that's when you see appraisals that pinned for way too long are sitting there. You see bad faith actions on the insurance company side. You see a lot of bias actions. And then there isn't really much for anyone to do at the end because unless you've documented it well and you understand what the rights are of the insured, you don't really know what to do with it. So that's kind of why this has become such a big topic in our industry is that we're just seeing them invoke it so much more than they ever did before, especially in Texas and Florida, absolutely in Florida. There was some more legislation that really put the focus on saying, hey, you guys should be utilizing the appraisal process more. I'm in front of judges all the time who have no idea what an appraisal is. They're like, I had an appraisal done in my house when I purchased it. I'm like, that's not what this is. And so that happens a lot. So a lot of times you find yourself educating people and dealing with people who don't know what they're doing. So the best thing you could do is make sure you're educated. You create a plan for you to handle appraisals. And then you force everybody on the other side to really conform to your plan. Because what the insurance company wants, unfortunately, is for it to be messy. That's what they love. Chaos and confusion, the person who's creating it is the person who gets to control and hide things that they don't want to get out there, and then they get away with it. And that is happening a lot in the appraisal process. So we'll go through, so that's me. So we are in Florida, we are in Texas, and we are in Louisiana. And so we'll start with invoking the appraisal process. Now, mostly everybody understands you've got to look to the language in the policy. And I cannot stress that more now, as of right now. You want to go directly to the language in the appraisal language in the policy and figure out what it's saying. What are those deadlines that are in there? Usually they say you have 20 days to name your appraiser and then also to determine the umpire. And if you can't determine the umpire between you and the appraiser, then you're going to have to usually get a court-appointed umpire. But we are now seeing more language in these appraisal provisions that are saying things like talking about those qualifications, that you've got to be an engineer, you've got to be a contractor, you've got to be a PA, you've got to be an adjuster. Those things are in there. But another thing that a lot of people don't see is that there are some policies that have appraisal as optional, not mandatory if it's invoked. So it'll say things like both parties have to agree. And that is so important because if the insurance company is demanding appraisal sometimes, they've got their own vested interest with why. And if you've dealt with appraisals, almost everyone can agree there are some claims that are just not good for appraisal. You prefer them to continue going and potentially go to litigation. And so if you get an invocation of appraisal from the insurance company, go straight to the language and figure out, does my client have to go? And you need to know that because the other thing that we've talked about before is that as our industry continues to grow, unfortunately, lawyers like to make money off of anything. I'm not putting myself in that category, but they will start pretty much marketing to homeowners. Has an appraisal gone wrong? Has there any malpractice that has been committed? That's what ends up happening, unfortunately. And as this industry continues to grow and you have millions of dollars on the table, that can be a real live issue for you and your malpractice. So you want to make sure that you're looking at that language because that is one place where it could be at, is that you've told your client they have to go to appraisal. They go, they don't get enough money because everyone's happy if they get enough money. But when they don't get enough money and it ends up being between the umpire and the appraisal for the insurance company, then they come back to you and they're angry at you. And then they find out they didn't have to go, that they would have had an option and you didn't tell them that. So you want to make sure you're looking at that language. It requires that written demand letter. You want to make sure that you've got letters for everything that are really nice and clean, not just in your email. It should be a separate letter, and on that letter, it should have your letterhead, it should have all the client's information, and a little secret is that it also needs to have the date and how you're sending it. If you're sending it via mail, via registered, via UPS, via donkey, whatever it is that you're sending. If you have that on the actual letter that you send to the insurance company, that it tells me how you sent it, that now becomes admissible that it was received, regardless if they say they didn't at all. And that's a little trick from an attorney's perspective, is that a lot of people aren't doing that. They're just sending emails and they're just saying, well, we're invoking appraisal, and then they're not actually putting that on an actual letterhead with the date that you sent it and then how you sent it, who you are sending it to. Tell me in the corner right here that you sent it via mail or via email, who you sent it to and their email address or their mail. If you send it certified mail, make sure you put a certified number on that letter. And I'm telling you, that makes a difference because you have some states where an untimely appraisal demand couldn't be ignored and then there's no way around it. So they can argue, well, we never got that letter. I mean, everyone's been there with insurance companies. It's really funny how they can get all the stuff they want to get that benefits them, but anything that benefits us, then magically it never got to their desk and magically it never existed. So that's why you want to make sure it's on those letters. Scope of appraisal. Here is another problem that I have seen a lot. You should have a memorandum of appraisal. I don't know if you guys have seen them yet. Plan is one of the appraisal programs that you can go to those trainings, and John Robinson will put together a whole entire packet of kind of letters. And I'm a big, big fan of that, is that you have your appraisal like in a memorandum of saying, here's what our scope is and what we're planning on doing. I'm the appraiser, you're the appraiser, we decided on the umpire of this person, here's the claim number, here is the date of loss that has been given to us from the carrier, here is the cause of loss, here is the scope of the appraisal. Scope means what are the categories of the appraisal? And if there's a category that's determined that you're not going to appraise, do not leave it blank. It needs to say not appraised. I have seen that I've sat in litigation where that's a huge issue, where nothing was written there, And the whole issue was that they actually just didn't appraise it, but they didn't write that they didn't appraise it, and it's considered a 0. So it looks like it was appraised and it became an actual 0. So make sure that you're going over the scope. What are we doing? How are we doing it? And are we in accordance with the actual appraisal language? So in that memorandum, you should also have the language written in that letter of what the language for the appraisal provision is in that policy. So you have it all written there. Gather all of your documents. So obviously making sure you have that policy language. The very first thing you should be doing as appraisal, I don't care if you're doing it for an attorney, for PAs, anything. It's time we take control of that process and you have your own procedures, step by step of what you're gonna do. And no matter who you deal with, you should be putting those procedures onto them. So you should be reaching out to the attorney, to the PA, or to the insurance company, whatever it is, and saying, here's what I need. These are the things that I need. I need to know, I want to see all the estimates. I want to see all of the invoices. It is imperative that you know what has been paid, because pretty much that's what the carrier has already accepted coverage for, and they paid it out. But you also should know what has been invoiced. We are all dealing with these appraisal process, and we're all human. And we don't want, and at the end of the day, we all should be on the same side of the insured. So it's important to know if they already paid for that roof to be replaced and what they paid. And that should be taken into appraisal. I tell all my appraisers all the time and umpires, I say, listen, we've got to do the right thing. Yes, if we were just dealing with estimates, sure. Okay, you guys want to decide to split the baby or whatever it is, and maybe we can find a roofer who can do it for that. It should be higher, but we may be able to figure it out. But if the insured has already paid for it, we should all be willing to go, is that reasonable, what they paid for? And if it's a little bit higher than what should have been reasonable, then we probably should give it to them at that amount. So they don't have to now be short everywhere else. Because we really are controlling this process. The appraisal process took what only lawyers and judges and expert witnesses were capable of doing, and now putting it back into the hands of appraisers, adjusters, and in some states, there are no requirements. So of people who just know how to write an estimate, or contractors. So you really have to try to control that process and make sure you're getting everything that you need. Photos, videos, weather reports, all of that stuff, everything that you need in the file, you should be going back to the insured, the PA, the attorney, and say, hey, these are the things that I need. You can even have a list of them and say, hey, here's what I need in order to begin this whole entire process. Timelines. So I make everybody that I work with document everything. Everything needs to be documented. You should be going to a system, whatever you're using, and writing notes. Every communication should be notated, because as appraisals get bigger, we are litigating them more. If you look at like most of the states, I mean, even Texas alone, a couple of years ago, they barely had any case law on appraisals. And in Florida, same way too. There's barely anything about appraisals in the appeals area. So as it continues to grow, there's just gonna be more issues. So one of the things that ends up happening is nobody's really creating those timelines. And you can create them because they're all just based on reasonability. I can tell you, because I litigate a lot, that a lot of the judges, I'm also part of the Florida Supreme Court Judges Association, so I worked with them a lot. I've had to educate a lot of judges on what this whole entire thing means. And one of the things, the consensus we've kind of all come to, and we've been able to get a lot of judges throughout Florida, is to agree that pretty much it should be 90 days. That's a reasonable amount of time to at least have 90 days, and then do a status report of what's happening after those 90 days. I've been able to convince judges to do it, and we have a bunch of attorneys that are now doing it also, and it literally moves the case so much faster. So what you should be doing if you're in the appraisal process is setting those timelines for yourself and for the appraiser on their side. Say, hey, we should try to get this done within 90 days or 120 or whatever it is, and have everything kind of set up. Like, we should do this within so many days, we should do the inspection by now, we should come up to an agreement by this time, and then we should, if we have to go to umpire, we go umpire on this time. So, but that's kind of what the courts are really kind of agreeing upon, is like pretty much a 90-day process depending on it. And I have seen appraisals, I'm sure everyone in this room has seen them, where they just sit there. And the busier that the insurance company are getting, because they're demanding appraisal more, you've got, I mean, I deposed an appraiser for the insurance company, which was not an easy thing to do because they don't like to be, courts don't like us to depose them, but it was a specific issue on fraud. He had like 460 appraisals like going out one time. I'm like, I don't know how you could ever do that. But it was like, absolutely. Like they're all sitting there. They're all waiting to move. They're all waiting he hasn't done the inspection on most of them. And then that's why you're seeing no inspections and they're just agreeing with what the insurance company has come to because they're getting so overloaded. So that's why you want to control that process and have those timelines in place, because if anything becomes unreasonable, it can be a cause of action to file suit. So if you're following up with the insurance company appraiser and you're like, hey, we were supposed to do this inspection, you never showed up, and he doesn't respond, your next email, the title of it should be second request, third email, fourth email, fifth email. You number those emails so you have that record and so we know what's happening. And then you should say, if you don't get a response back, I have PAs tell me all the time, like, I can't hear back from the insurance company. The appraiser won't respond to me. And so I'm like, okay, well, this is what you need to do. Number those emails and then set a deadline. Say, listen, if I don't hear from you by Friday at this date and time, I will assume that the carrier has now waived their right to appraisal. If that's what you want, if you didn't even want to be appraisal, you can potentially create it that way. If not, then you'll let them know that you'll reach out to the attorney or the PI on the file, because now we believe that the insurance company is not dealing in the procedure that they should really be doing. So you really have to kind of control that process too with them. So that goes back to the documenting. Every failure, every issue that comes up. If you have a phone call with them and you think something said in that phone call that would be important, go to your email. That's when you see those as per our discussion, as per our recent phone call, as per that. It's to create that actual evidence that could potentially be needed later on. So making sure you have all that. So there are times that the insurance company can waive their appraisal. Texas has a lot more opportunities where you can actually say that the insurance company has waived their right. So if the insurance company in Texas is unreasonable about their time, if they were given enough time to provide coverage and determine if it was covered or not, and you sent the proof of loss, and it has been an unreasonable amount of time, and then there's already a dispute, you said, hey, we want this, you went back and forth, and you're at a standstill, and then it sits for a little bit there, and then they demand appraisal, there's a potential it could be considered a waiver. A denial of a claim is a waiver of appraisal provision. And like in Florida, we don't have as many different ways that you can waive the appraisal. Really in Florida, it's only if the insurance company denies the claim and if they participate in litigation. Like if we file suit and then they start litigating it and then they try to demand appraisal, it can be considered an untimely filing of the appraisal award. The appraisal demand. So these are things like always having a good attorney you can call and ask free legal to. I'm sure they do it too. Most attorneys will do that and say, hey, this is what's happening. These are the facts. I get it all the time. I get screenshots of letters that come in during the process from PAs or the appraisal process or any of those things, and they're maybe asking me a question. And so that is good to know that there are certain times that it can be a potential waiver of the appraisal process. So and that's where Florida, we're talking about just denial and participation in litigation. So coverage versus causation versus scope of damages. This is something that was just talked about a little bit in the main stage. And pretty much this is where most, yes, go ahead, go, talk.
Question.
Yeah.
Are these slides going to be available to us?
Yes, I can get them available to you, yes. Absolutely, just email me. You have my card, just email me and I'll send them all over to you. So this is probably the most disputed concept in appraisal right now, and several states are all in tough litigation right now about what that means. Now, coverage means if the insurance company is going to open any coverage for that claim at all. That cannot be determined in appraisal. Now, causation is what actually caused that. What those items that you're seeing, are they all connected to that date of loss, that cause of loss? So every claim is specific to date of loss, cause of loss, date of loss, cause of loss. So if they have not opened coverage at all and said, we have not covered anything in this and we're fully denying it, it cannot go to appraisal, and also appraisal panel cannot determine if there's coverage. Now causation, which is just a play on words sometimes, is if that room over there is connected to that date of loss, cause of loss. That's what causation. What caused that damage? Is it part of this claim? That is what an appraisal panel can determine. And for years, appraisers said, we can't determine causation. We can't determine causation. And it's not true. It's pretty much what you're doing all the time. Just like I think, Renee was kind of saying a little bit, is that when you go out and you determine what an estimate of damages are, unless you're going to a brand new house, there are some things there that are absolutely wear and tear or over time and all of those things that are not covered. And pretty much you're probably sitting there with the appraiser and you guys probably maybe agree on some of those things because it's obvious that that's not from it. And so that's really what happens during the appraisal process, that you're technically always kind of doing causation. It's kind of always happening when you're writing an estimate, especially if your scopes are off. Unless your scope's exactly the same, there's some talk or negotiation about causation. And then that's usually what becomes a stickler a lot of times. It's not usually just price. A lot of times it's scope. And scope really is causation. And so depending on what exactly is happening during that appraisal process, that is when it could, depending on what state you're in, is that if you determine that there's a big issue about causation, there's something just big. We think it's part of this hurricane. They're saying it's not. You can have times an attorney can file suit literally while you're still in the appraisal process or potentially afterwards to determine some of those issues that may be uncovered. But I'll tell you that most of the courts are saying, hey, we do believe that the appraisal panel should be the one empowered to determine if it's causation. And that's after if the insurance company pays even $1. So I have a case where it was kind of like there was a fraud issue about that, was that they opened coverage for mold under just the 10K limit, and we're like, we're opening for this, so we're covering it, and that meant it was still able to go to appraisal. But all of the other damages, which is about $300 and something thousand, which really came from a water loss that created a collapse in the house. That was really the issue. It was never the mold. The mold, they opened it and they said the cause of loss was really mold, which is a whole other argument there. And they already paid that. They fully had tendered that. And then they asked for appraisal. So we went through the appraisal process, and they're determining now the damage that they think has taken place. And then the appraisal number was around $300,000 that they agreed to. But the actual cause of loss that was there was always under mold. So it did become a causation issue, and those two appraisers thought they could not determine causation. So what they said to each other was, we can't determine the causation, let's just write for what we're seeing, because we're seeing that there's water, and yes, there's mold there, but we can just give it to an attorney and they can fight over mold. But actually, they should have been the one fighting over causation then. Even though the cause of loss and date of loss that the insurance company filed, that's another thing that you see too sometimes, is that your client may have said, this is a water damage, or they may not have known what it is. And then you have a carrier who decides that it's whatever they think it is. Just because they've decided that doesn't mean you have to continue following down that hole. You can say no. If you're in a PA, you can say no. We believe that the cause of loss was this, and that's what we're proceeding under. So you've got to be real careful when you get to that appraisal process that you guys do have the right to determine that causation. So if the insurance carrier is saying it's mold, and now you're at the appraisal, and you both are kind of saying, hey, we think it's water, that's what we're seeing here. We're not here to determine this collapsed house under mold. That's not what we're here for. Then you guys have to address that then. Can't wait to get to be addressed later. Has to be addressed then. Yep.
And if they try to, if the insurance side, the PA, or not PA, appraiser tells you, hey, I don't want to deal with this, tell them like, hey, if you've ever had a zero award, you've made a causation decision before. Because if you go up there, even if it's wear and tear, it's the most obvious wear and tear you've ever seen. If there's a tree right directly above it, just rubbing on it every day. You're still saying, well, I'm not going to cover this. So they can't, in good faith, say, well, I don't make a coverage decision.
Absolutely, and they will. So that's what we go back to, going back to your email and saying, as per our conversation, we talked. I'm not going to call you an idiot, that you don't know what you're doing, but we had a conversation and you stated that you did not want to deal with the causation issue, and that is a live issue in this case. So you've got to really memorialize that and figure out what you're going to do with that going forward, because a lot of states, the reason why appraisal was created in arbitration, they are alternative dispute resolutions. It was the idea for the courts to say, listen, pump your brakes. we got a lot of lawsuits being filed here and we don't have very many resources. So let's create these alternative ways so you don't have to end up in litigation. So because of that, courts hate litigation about appraisal, arbitration, any of those things that are supposed to be those alternative dispute. So that being said is that it's very hard, especially in Florida, to get a court to reopen that appraisal panel. They really feel like it's protected and it's the court's obligation to really watch that. So if you let that go, like he was saying, even if you try to document it, but you let it go and you go, well, I guess we won't determine causation and I'll just agree on the award or whatever it is, then it's almost impossible to get it to go to attorney now and go, hey, now I need you to overturn this. So it's very similar, I was thinking before about that whole mold claim that we end up getting. And I was like, it should have been addressed there. Should have been memorialized there in an email and saying, well, we have an obligation, we can determine coverage, and there's, a causation, and we have a causation issue here, and you're now saying that you are refusing to do that, period. So I'm going to take this as your refusal to do your obligation as an appraiser, and I'll be informing the PA or the attorney whoever's in control of the file or the insured. And pause it, stop it there. If that issue is so big that it's going to mean the difference of a chunk of money, especially for an insured, a chunk of money for a homeowner, then you need to get control and stop the process. Because now you can go back to whoever it is. Like if you came back to me with that concept, I would go back to the insurance carrier and tell them exactly what's taking place and go, here's your options. Within 14 days, I need to know your position. Either your appraiser has done X, Y, and Z, which is in violation of their obligation under law and under the policy, and then we can either have a new appraiser signed by within 2 weeks, or I'll assume you guys have waived your right to appraisal. I use the waiver to appraisal a lot because I set them up and say, if I don't hear from you, I will assume X, Y, and Z. And then when I don't hear from them, I'm rightfully allowed to assume X, Y, and Z. I didn't hear anything. And that is used in court all the time. A negative or a failure to respond is considered a response. So making sure you're understanding that and going, okay, pump, we're going to stop right here because this is not going forward the way that it should be going forward, and I'm not doing my service to the insured who I'm the appraiser on this file for. So signing the award. I am a big fan of never using the insurance company's award letter. And this is that example I was telling you that was about mold. Well, it's another example about a mold claim. Is that they had fought too about it being mold. And so the type of damage, this actually was printed up by the insurance company who gave it to their appraiser, and then this is the award letter that the appraiser for the insured signed. And he signed it under the type of damage, which was mold, and then the amount that was there. And so this actually on paper looks like both appraisers are in agreement of that being the type of mold. But actually, both appraisers did not agree that. They didn't agree that they believed that the cause of loss was mold. In this claim, they believed that it was water. And so that being said is that you have got to watch what you're signing, every single word of it, and ask an attorney. Like, so much we're seeing letters getting drafted. I mean, I'm sure you guys have dealt with it. If you've dealt with any contractors, you know, I have seen the most horrific contracts I've ever seen in my life within the last 5 years. I mean, especially after a hurricane. I mean, I think they write them with crayons in the back seat of their car. They copy and paste and put it together, maybe Xerox it on a copy machine. I don't know. But font's all off, it's all crooked. And they're like, this is right? This is good. I'm protected. I'm like, I don't even know what this is. I'm like, you've promised to do nothing, and they have no obligation to do anything if they don't do anything. And so when you're signing something, you're signing a document. It's binding. Anything you sign your name to, you better make sure you read every single word of it and you understand what you're saying, because the insurance companies have no choice but to get dirtier. They do. It is. If they paid claims legitimately all the time, they would never be in the position that they're in now. Everybody knows that. It's a business decision. And I know in their head, they probably have convinced themselves, when they're on their yachts and their jets, that we're doing this for the good of the people. We have to deny claims. We have to figure out ways to get around legitimate claims in order for us to stay alive so we can help other people. Like, that's what they do. That's welcome to the world of politics. And so that being said is that you now have to be super diligent in what you're doing, because they are going to get dirtier and dirtier. And one of the things that they would love, and I've heard them say it before, is that when an insured doesn't like what's happened and they call back the insurance company, guess who they're going to throw under the bus after an appraisal? It'll be you. It'll be you. They're going to go back to these documents that are being signed. I've seen crazy stuff being signed, and you've got to watch what you're being signed. That's why you should be creating your own documents for it, and if you're confused on what it is, send it over in a text message to an attorney like myself and say, hey, is something I should sign? What does this all mean? You don't have to pretend to be lawyers and understand everything with legalese. You can reach out to the attorneys that you know, and most of the time I know I do, and I know a couple of other attorneys do the same thing, is we really try to help you guys understand those things.
So in your experience, you've seen appraisers that are working for the insured be able to successfully say, hey, I don't want to sign your award letter, I want you to sign mine.
Oh yeah, because guess what? There's no rule that says what the award letter is supposed to be. There's nothing. There literally is. That's the reason why I'm saying take control of the claim, because the rules are right now, until it gets more regulated, there are no rules. There's no rules of what has to be submitted, what has to be reviewed. Do they have to do an inspection? Do you have to sign this? Any of that stuff? No. So act confident, be loud, and tell them what it is that you want for the best interest of your client or the person that you're representing in regards to the appraisal. So absolutely, I've told them that several times. And it has sometimes turned into a disagreement between what form. And then all of a sudden I get a call from the carrier's the attorney from the carrier and saying, hey, your appraiser won't sign this award. I'm like, because he's not going to sign your award. I'm like, there's nothing wrong with the award. I'm like, send me your award and let me see the one that we're trying to ask you to sign, and let's go over it. Let's figure out what the difference is between the two. Because I can pretty much promise you that there probably is a difference with what you've sent them. So absolutely. Or if they say no, then I always tell everyone, ask them, please show me where in the policy it says that the insured's obligated to sign an award letter from you. Yeah, same with like proof of loss. Some policies do say, we will provide you a proof of loss to fill out. And some of them don't. And you don't have to fill out their proof of loss. You can have your own version, create that, as long as it's substantially in compliance with what they were producing, what the insurance company wanted, you'll be fine. So sometimes even using their proof of loss letter. I avoid anything the insurance company creates. It's like a plague. I'm like, absolutely not. I'm like, it unfortunately is a trap. They're producing things that are in their best interest, never for the insureds, fortunately. So
question
yes.
for you then. So you
Yeah.
mentioned, going back to the award.
Yep.
You mentioned a couple red flags.
Yep.
Where it shouldn't be left blank, say unappraised.
Yep.
Or zero.
Yep.
And this one here, the cause of loss, they have this mold in,
Yep.
but it was water, right? So what other red flags then am I looking for? Because this
Yeah.
is typically what I see.
Let me show you one. Let me go through this real quick and show you. So it says here, where this is a form from the carrier. Where we have found no loss under a particular category, we have indicated that by placing 0 on the line for the coverage, and our findings are as below. Only under mold. Where are all the other categories? Not telling me that it wasn't, that it even conflicts with what's being written here. So now it becomes arguable to a court if we try to go back and go, hey, these areas were not appraised, so we now need to get them appraised because now we're having a dispute on ALE or any of the other stuff. They could say, well, the appraisal award's here, we had all categories in there. And so this should be binding, that's all that matters. And when you go to litigation, this is literally, the 4 corners of this document become the entire contract. The attorney's fees, costs, and courts and interest are not included in the appraisal award. That's none of your business. Like, that has nothing to do with you at all. Like, you shouldn't even be signing anything that says any of that. So when it says, because all that's inside the policy, that the limitations and any prior payments and all that stuff is going to be taken out, that's all policy language. So it really should be, the award is, here are the categories, here's what we agreed upon, here's the amount, here's the numbers, and here's RCV, and here's ACV. And that should be really all of it. Depreciation, any of that stuff. And the signatures by everybody. Very, very simple. The more language that's here, the more likely the insurance company is going to use it against you. That's why I'm real hesitant about the proof of loss also. I'm like, we have added provisions to proof of loss. I mean, the proof of loss, no matter even if the carrier does have the policy provisions that say you have to use the proof of loss we provide for you, I'm like, great. I edit it. We add stuff to the bottom. I'm like, this is subject to change with the discovery of new information, additional damages. Something still hadn't been, I don't have all their contents lists. I put all that there. Because what they love to do is you give them a proof of loss at the beginning of the claim. Claim has gotten bigger. It's gotten worse damage over the time because they hadn't been paid enough. The client hadn't got their contents report. If you've ever done a hurricane claim, you know how that works. Trying to get a contents report is literally like asking them for their firstborn. Like say, hey, just give me your baby and we'll be good. And they're like, I'm not gonna give you my baby. I mean, asking them to do their contents, like, I don't even know what I had. You're like, okay, I'll do it with you. So we are always there trying to take pictures of their stuff, like walking them through it, being like telling them how to, we're on the internet looking for what the value of stuff is. So, but you had to send the proof of loss already. But now you potentially have more information and they love to look at that and compare it and go, well, this was your proof of loss and you sworn to this being the number and that's it. And that's something that they just started doing, which I always believe they always could have done it. They could have always utilized that proof of loss more because it's being notarized. That is their true damages, nothing more. Guess what else is in their proof of loss? You probably have seen it. It also says that this property has not changed usage for anything at any point in time. So there's also more language in there that also it's designed to help the insurance company potentially go after material misrep in the policy. So we've had times before where when they procured the policy 2 years ago, they didn't have a renter in the house. Then 6 months before the loss, they had a renter in the property. So then we file a claim based on what happened, and the renter actually had renter's insurance, and the client has coverage for the whole loss. And they signed the proof of loss that says there's been no changes in the property, but there has. There's been changes from when you procured your policy, because your policy majority of the time asks you in the application, what is the primary purposes for this resident? Is your primary residence? Are you renting it out? So that little language there that they snuck into the proof of loss that has no bearing on the proof of loss to determine what the client thinks their damages are, is if their property has changed for purposes. But that client goes right ahead and goes, okay, yeah, it hasn't changed. I don't know what that means, but I'm going to just say no. Guess what? That is a material misrep. And every policy, not only do you have to not have any misreps on your procurement of your policy, but through the entire process, through the entire claim, you cannot misrepresent anything. And that is a misrepresentation. So that's changed. So that's another reason why you have to be careful with the stuff that you're signing from them.
So it's not just in that policy period?
Yeah, it's at any point in time.
Since the initiation of the policy.
It would be potentially since the initiation of the policy, and then however long it takes them to actually fill out the proof of loss. So they're asking you, has anything changed? And it had. Yep. So those are some of the big parts that are in a letter like that.
See,
Question?
that's interesting because to me, I see what you're saying because it's already in the policy that everything done prior to the appraisal should be not included.
Yep.
But it sounds like you're saying if I see that, I should demand that they remove that?
Well, it depends on what exactly it says. So that's really what the important thing is reading what it says, taking it line by line and go, am I okay with agreeing with this line here? Can it be used against me in any form or fashion? Like any of those things at all. So if the line is just that this policy is still subject to all the provisions, all stuff, maybe that's fine. But it could potentially say something else in there that you're becoming responsible for, or something that you don't even know what they're talking about. They're like, I don't need to sign anything that's literally holding me to any more obligations than the already obligations I have. No. So reviewing the award letter. So this is another area where they make a lot of money. So you guys all know recoverable depreciation and law and ordinance and all of that goodies. But what we're seeing them also do is they take an award and then they're breaking it up and they just magically decide what's law and ordinance, what is depreciation that wasn't agreed during the appraisal process. So that's why it's so important once you get that award letter, this is that payment letter. Okay, so if you happen to be the PA working the file and there was already someone else did the appraisal or you're doing the appraisal, you want to make sure that when that payment award letter comes in, that you're understanding that has to be compared to what was actually done during the appraisal. Because a lot of times with the appraisal, there's no requirements that there is an estimate. A lot of times there are. Obviously, that's if you're doing your job, you come to an agreement. Somebody should be creating an estimate. Both appraisers should, and then the umpire should. But if you've ever done an appraisal, I'm sure you've had times where they don't, where the umpire doesn't create one and the insurance company appraiser doesn't create one. And so that being said is that then when it gets to the insurance company, it's hard. It's like, how did you decide what you were breaking down? If we were the two appraisers and we agreed, and I had my estimate, they had theirs, and we just agreed on a number, and that's how we came to it, there is no actual scope of repairs that we've agreed upon a scope. We just agreed upon a number, which happens a lot. And same with the umpire. They've agreed on a number, but there isn't an actual estimate that has broken everything down. And the insurance companies love to get it, and then they'll break it down themselves. So you want to make sure that this payment award letter, the actual letter, is reflective of what happened during that appraisal process. Because they make their most money in law and ordinance and recoverable depreciation. There are trillions of dollars sitting out there in recoverable depreciation that no one ever came back for. Because what insureds don't understand what that means? And then they have timelines. You see it at 180 days to come and request that you want your recoverable depreciation. There's also language that says, if you don't let us know within so many days that you're seeking RCV, you've waived your right to the depreciation. There's all kinds of crazy language now. So they love to put money in those categories, law and ordinance and recoverable depreciation, because the odds of the insured coming back are very slim. Yep.
So on that topic of depreciation, appraisals take months, at least, sometimes a lot longer than that. Obviously, deadlines get blown with depreciation. Have you
Yep.
seen the insurance companies pretty routinely release a depreciation within a reasonable time, or have you seen any pushback in that area?
I will tell you that I have only seen slight pushback, very slight. And I'll tell you why, because I know for us as lawyers, if they tried to push back on a recoverable depreciation, then I would go harder on my breach of contract and bad faith. Because the only reason why, like any of my hurricane claims, most of them, they don't get the money they need to do the work within 180 days, let alone find a contractor who can do it within 180 days. So that being said I think that they understand that. I have a lot of friends for the insurance company because we've had this debate, that they understand what it would open for them, is because that's exactly what it would be opening, is the potential. Now lawyers like us would get on and go, absolutely. If you're trying, just like they say, failure to mitigate, I laugh. If you're the reason why they can't mitigate, because you haven't given them enough money, you can't then go back and say, hey, you should have mitigated. I mean, reasonable things, absolutely. When you're like, you should have put a new roof on, you should have repaired the roof. Well, you didn't pay for any of that. So I didn't know that that was a requirement when they got a policy. They also had to have $15,000, $20,000 in a savings account in order to fulfill their obligation. So they broke their obligation first. So that would be kind of like what happens in most of these cases. So they haven't made a big deal, but I err on the side of, I do believe, and everyone obviously can see it, they're going to start just grabbing for straws, any way to save themselves money. Yep. So that's why there's some policies that have that language that say that you have to let them know of their intentions. So one of the things that we do in our original letter, which is a great way for you guys to do it, your LORs and all that stuff, is to just start by saying our client intends to have coverage for their RCV. They plan on replacing the property, repairing and replacing the property. I put it at the very beginning. I'm like, even if my client isn't sure what they're gonna do, I'm like, you want it there and we can figure it out later on. So it's there. Because some of them say you have got to let them know within that timeline. Yeah, and that is something they could potentially try to hold against you. That would be stronger, is your failure to invoke it. Yeah, which is crazy because you wouldn't think that. You paid for an RCV policy. You're entitled to RCV. So they should be paying, they pay on ACV and they give you RCV when you actually repair the property or replace it. But instead they're like, you need to let us know you plan on going after RCV. It's like, well, that's why I paid for RCV. If I never come back and ask for it, then it's good for you, but I shouldn't have to then now tell you that I plan on doing that, you know? So that's a good way to kind of upfront some of your letters, because that's another thing the insurance company is kind of, I've seen them push back a little bit on that. Yep. So, yeah, go ahead.
A follow-up question.
Yeah.
So on depreciation, and the awards establishes the ACV amount, okay? If the percentage, whatever percentage the accountant's applying for the depreciation, if that conflicts with the policy where there's a schedule, depreciation schedule in the policy, which one?
The policy wins. The policy wins specifically in appraisal because the appraisal provision language in the policy says that it's always subject to the policy provisions, limitations, exclusions, et cetera, et cetera. So that means the part that wins is going to be the policy. Yeah. So, and just a little reminder, like if you're in Florida, law and ordinance is when it's been incurred. Incurred for law and ordinance in the state of Florida means you have a contract with a contractor. It doesn't mean you've had the work done. It also doesn't mean that you've actually paid for it or been invoiced for it. So that's a little kind of like a little caveat there that makes it really great in Florida to get that L&O and stuff like that release is just by a contract with your contractor. Okay, so this is something else when we're talking about talking to your attorney. So a little bit of the case law is just saying this is anticipatory is what it's called. Anticipatory breach of contract is what it is. And that's based on the conversations that are happening between you and the appraiser. Why it's good to have an attorney somewhere you can talk to and run things by them. Because there are times we can file suit prematurely and in a good way to say, listen, there's obviously an issue with this appraisal process, and we're going to allow it to go forward. There's something called a dual track. That's what this is, a dual track, where we're going to allow the appraisal to go forward as far as the amount of damages, but there's a live dispute right now as far as causation, coverage, or any of those other things, and we can file suit literally while you're still in the appraisal process. While the litigation's going forward, you guys determine the amount, and the litigation will determine what's covered and what's not covered. So that's why having this communication with your attorney and asking those questions when you run into them and say, listen, this is what the insurance company is saying, I mean, the appraiser for the insurance company is saying. I don't think it sounds right. I think it's an issue. What are your thoughts? Because we can go, okay, start documenting it, and I'll start sending my emails to the insurance company and tell them what we think is happening. We've stopped a lot of appraisals that way, midway in the middle, and said, Because once it's done, it's very hard to unravel it. Once you sign that letter, it is very hard to unravel it. So stop and get the answers that you need to where you feel comfortable that you're not just going forward. Take that control over the claim. Question? No? Yeah.
Yeah, just, as a corollary to that, the insurance company, and it's even in the policies now, they'll say, well, we don't have to pay the appraisal just because, so if you fight for the appraisal and it's a good award and they don't pay it, then you have litigation. If it's a bad outcome and you sign it, you really don't have anything you could do in litigation. If you say, okay, $5,000 is a compromise,
Yep.
then what can a lawyer do for you?
Yep. Absolutely. Or they'll just let it go to umpire. They're like, let's just let it go to umpire and take the risk with umpire. And I'm like, that's it. Even though you didn't sign it, now you had to let them sign it, and we have now an assigned award that we have to try to unravel, which makes it a lot harder. So stopping it in the process and trying to be proactive with that is just imperative. And so,
You said you've had
Yeah.
success with the judges putting a timeline on appraisal.
yeah.
Have you had appraisers get upset with that, or umpires, or?
Yeah, because they absolutely don't want to have to move any faster than they're moving, and everyone's doing things. And so I don't necessarily think they've gotten angry about it. I think it's actually helpful because I think a lot of times one party is not responding, and everything else that we do in this industry, you have to respond to. But all of a sudden this appraisal process comes in, no one thought it was ever going to be really utilized, now it's being utilized massively, and the rules are there are no rules. So these processes are just like sitting there. So the good thing is I make the judge put a 90-day on it, and then we just come back with the case status. So we go back to our appraiser and say, hey, where we're at. And it really does push the cases forward. Okay, this is a reasonable amount of time for it.
What's the argument to the judge? Just because there's obviously no case law, right? And it's not in the policy. So what are you saying to convince the judges
That it has to be reasonable.
just
The reasonableness follows every single provision in an insurance policy. Everything has to be reasonable. And every process has to be reasonable. So that's literally what I said. Say, Your Honor, 90 days is what we should do reasonably to say, listen, that's enough time and what we do every day to say, you can get somebody out there, look at it, at least have an idea of where this case is going. Is it going to go to appraiser or any of those other things? And to potentially have it resolved. It really should be. I mean, it really shouldn't be pending all that much longer for 90 days. And that's how much most states give a carrier. A lot of states give a carrier 90 days to do their stuff. So, and much less than that in some states. Some days you have 15 days, some of them you have 30. You know, you got 15 here, you got 30 over there for them to acknowledge and sometimes make a coverage decision in Louisiana. So that being said, it just said it's reasonable. And if they're not there, we at least get an idea of where they're at. Then we come back for a case management conference setting and we say, hey, this is where both parties are at. And then we reset it again for 30 days. Yeah. So just letting them know, saying, listen, this has got to move reasonably. And that's what I'm talking about is like, don't let them make the rules. And that's what they're doing now. And they're going to continue doing it as long as we give them that rope. They're going to continue doing whatever they want.
The carriers like it, and it
Love
goes
it.
a year or two.
They have no more obligation. They have no more obligation to do anything while it's sitting in the appraisal. They don't have to worry about what their desk adjusters doing, anybody's doing. They're not technically open anymore. I mean, some states have given you more leniency to still file for bad faith and all that stuff afterwards, but a lot of times that appraisal process, once it's complete, it's the surefire way for a carrier to kind of put their hands up and go, we don't really got to do anything, we're just going to pay when we get the award. And a lot of courts are saying, we really don't want you filing bad faith after that. Like if you guys have seen how the legislation has been moving, even here, Texas, Louisiana, they really don't want you litigating afterwards. So they love the appraisal process, and the longer it goes, they absolutely love that too. They know they're not paying them anymore most of the time, the appraisers.
Is the insured covering attorney fees for that, setting that deadline, or have you had any success getting the carriage to pay those?
To pay the attorney's fees for?
For having the court manage, case manage?
Oh yeah, yeah. So if it depends on how we got into litigation, but majority of the time, a lot of the cases that we have, it's litigation, then the carrier will finally demand appraisal. So then we stay the proceedings and go to appraisal that way. And then I've had a deck action filed. We filed deck action before when the appraisal just had become a mess. And so we have a couple of those where those are in litigation, and then the judge is the one overseeing them. And there will be, I believe, a lot more. I mean, even in the past 3 years, I'm shocked with what has changed with the judge's knowledge of what this process means and what it looks like. Yep. Question, anybody else? What you got?
See, I have a lot of people that come directly to me for appraisals.
Mm-hmm.
And what I learned recently is it's not necessarily a good thing to you attorneys if the appraisal was invoked prior to a civil remedy notice. Is there nothing that I could say to the clients that are coming directly to me that doesn't make them think I just prolonged the process? I say, hey, all right, I got this appraisal going for you, but I think it would benefit you to also sign this attorney's contract. Because I see the benefit of having y'all file motions, and if I don't like the umpires, have y'all request a court name one. But what do I do in that scenario where it was engaged prior to litigation and prior to civil remedy notice? Is that not beneficial to you?
So it all depends on what the facts are. So I'm very, very careful with, I'm not the person that threatens things that I'm not going to do. If I say I'm going to do it, you better bet your money on I'm going to do it. So I'm not a fan of just throwing civil remedy notices and pre-suit notices for bad faith. I have to see that bad faith and has to exist. Because it's just like crying wolf. We have too much in our industry is there are firms where we're no disrespect to them, and their policy is every time we file a suit, we file bad faith. We file a CRN. We always file bad faith. That's just not my thing. I don't say things I don't stand behind. But if I say it, and every insurance company knows, if it comes out of my mouth and I threaten you and tell you that you're proceeding in bad faith, it's legit. I'm serious about it. So that being said is you got to look at the facts of it and figure out when the client comes to you, if they come to you and it already has issues of bad faith, you're seeing that, adjuster has changed their report. They said things to the insureds that were lies. They misquoted the policy, all of those other things. Any of those things that could potentially be bad faith, and they come to you, then it would be beneficial to go and talk to an attorney and say, hey, at least run those facts by the attorney and go, this is what I'm seeing. Because once you get into the appraisal process, like in a state like Florida, The new legislation is you can't file CRN for 60 days. So we used to be able to do it, and that's what a lot of attorneys would do. They'd file a CRN, and I'm not a fan of, I'm all about let the insurance company be the only one doing what's wrong. That's it. Two wrongs don't make a right. So a lot of times there'd be plaintiff's attorneys and they would say, or PA's ideas like, hey, let's file CRN when they do the appraisal because they're not going to be able to, by the time they have to respond to the CRN, they're not going to be able to finish the appraisal, and then they're going to pay appraisal afterwards, which could potentially lead them to bad faith. So it's like a setup. So I'd say look at those facts, figure out if you think that they're right for that, and then talk to an attorney, because absolutely you'd want that CRN to be filed to have those facts in place before the appraisal happened, because it makes it a lot easier afterwards when the appraisal's done that we're going back to those original arguments that existed. So that's what I would say, looking at those things. Question?
I need an Illinois referral.
Yes. Yes. Gotcha. I got you. Give my card. I've definitely got you. Question? Yes.
So I might have missed this, but
Yeah, sure.
there's been a kind of like lingering conversation between some PAs, and I'm not understanding the appraisal and then bad faith suit.
Yeah.
Can you do that? Maybe it's a state by state thing. I think we're talking about Louisiana when they say you can't, but
You can. So you can, but it has to be, it's every state's a little different on what they will allow become a bad faith afterwards. So like Texas will say, okay, let's look at, they just started looking more at the disparity, but the difference in numbers really between what the insurance company paid pre-appraisal and what they paid afterwards. But you have Florida where that's absolutely not admissible, them numbers. You're supposed to go back to the facts of bad faith are the behavior of the insurance companies. What did they violate in their code and their laws in order to bring the case here today? And so there are times when even though you're in the appraisal process, those facts still stand, and the appraisal process is just going to determine what the amount of loss is, but we still believe that there are other issues that have arisen that now the client's potentially entitled to consequential damages, other damages because of the insurance company's failure. So they like to let a case linger for a while, an insurance carrier does, and then all of a sudden they'll demand appraisal. But it's like the client's been sitting there for a year and a half without any of this stuff fixed, so that's not going to make them whole. They came out of their pocket for interest in their credit cards, they lost this or that, whatever it is. And so those are the potential extra contractual damages you're going after. So that's why they do it like that sometimes. Okay. We've been telling where the light, or we have an hour, right? Oh yeah, okay, we've got a couple more minutes. Other questions? Anybody else? Yes.
Anybody? So, you own multiple businesses. You're not just an attorney. You're actually the owner of your company. You own one of the best clubs in Tampa.
Club Prana. If anyone's coming to Tampa through, I'll get to let you guys in free.
First party property loss is not that sexy. What made you choose this?
I chose this. So when I first became an attorney, I knew that I wanted to find a way to help people and not have to charge it to them. That was a really issue for me. I was working for attorneys that were charging $350 and $400 an hour. And when someone reaches out to an attorney, it's in the worst moments of their life. And no matter how much money you may have, $400 an hour adds up really fast and is very unreasonable to me. So I was like, I got to find some way to help people and not have to charge them. And so I had a client who came in who the insurance company had screwed them over, and it changed my life. And so that was about 6 years ago. And so I didn't know anyone in this area of law. You don't learn it in law school. Most attorneys I know have no idea what first-party claims are. They're like, what are you talking about? So I had to figure it all out. Every demand letter I have, everything I created, all was created by myself. And it was because I wanted to figure out a way. And so like in Florida is where we started. The best part about Florida is they have statutory attorney's fees. And that was what changed everything. I was like, oh my God, I can charge the person who's doing wrong to them for this litigation. Amazing. And so that's why I did it. And then I got really attracted to hurricane claims after hurricane. So if you know us, we do a lot of pro bono work. We give food, gas, water. We take RVs out there with boots on the ground. We get there right away because I volunteered first with Hurricane Katrina and realized there was nobody there. No one's there helping them. And then when I learned about insurance claim and realized they had no idea what they were doing, it was just insult to injury. So that's why I did it. Thank you guys. If you need anything, let us know. I will always give you free advice. Most people who know me, who've been here, they reach out to me all the time. They know that about me. Just send me a text message. If I don't answer, they know how to write question mark, question mark. It means they want to answer right now. But if I never see a file from you, I'm not a person who takes it personal. I think that's a great thing. If you guys are selling stuff, my job is to help you be able to do that and never need us. We have a place. There'll always be a place for us.
Perfect.
Thank you guys. Get some swag back there. Anything you need, let me know.
Awesome.
Thank you. Thank you, my love. We try. I went to Stetson. Stetson in Florida.
Florida?
Yep.
Okay,
So it's in Gulfport. It is the #1 trial litigation school in the country.
Okay.
So we're #1. So
I
yeah.
actually wanted to go to law school in Florida. I was
did?
looking at Miami. Well,
Yes,
I do. I still
yes,
do.
yes.
But I'm not familiar with the different schools. Like, I don't know a lot about it. I don't know what would be best for
Oh my
me.
God, yes.
I would love to get your contacts.
Of course, yes.
Because,
My card's back there. My cell phone's on there.
okay, amazing.
You shoot me a cell phone. Text messages. Tell me who you are and say, hey, can I rack your brain and just talk to you for a little while?
That's amazing.
I'll give you
I'm
whatever
India, by the
advice.
way.
Hi, Candice.
Candice.
Nice to meet you.
Thank you so
I'll give you
much
anything
for
that you
all the
need.
information.
Of
Like,
course.
I feel like my brain is like fried right now because I'm trying to just take things in, and I'm like trying to also get out there and network. And I'm
Yeah.
like, there's not enough room for
There's not
me to
enough.
be like selling
Yep.
myself at the same time as receiving information.
Exactly.
So I need to like sit down and decompress.
Yep.
But I would love to talk to you further
Absolutely.
when I have a clear brain. So I will definitely get your card.
Please, anything, anytime that you want. I'm never too busy to help another woman.
Thank
Yeah,
you.
no problem.